Right, if you look at section 1.2, the service provider may provide at the district's discretion emergency medical first responder services. And here, this section here varies on a case-by-case basis. So the bottom line is that we need to see what your actual situation is. For example, here in Travis County, we do first responder. We are also all confederated together under the county who does the EMS transport through a contract with the city of Austin to make it even more complicated. So it would just depend on who's actually in charge, but really the district ultimately is in charge of first responder or EMS services, even if it's a volunteer fire department, and making sure that you have the proper personnel training, your first responder organization, agreements, certifications, whatever you need. And that section 1.2 would be something that we would work on an individualized basis. And then if you look at 1.3, this is authorizing the service provider to provide mutual aid. Now, of course, you don't want to subsidize with your taxpayers' money the provision of services to another area outside the district. One of the issues that can bring up is sometimes you have service providers who are not wholly within the ESD, who actually provide either the whole ESD and somebody else, or a part of the ESD and somebody else. And so the contract would vary depending on that fact pattern. But the bottom line is that you still don't want to subsidize your money going to provide services somewhere else. You can certainly do that through mutual aid, and you can do that through other agreements, but you don't want that to be a standard operating practice. So you can even see at the bottom of 1.3, any such agreement shall be provided to the district for approval prior to execution. And I'm more than happy for them to enter into everything that they feel that they need to enter into, but also it's for you to know what's going on and what your money is going to, and that what your kind of commitments are outside the district. And this is one of the ways to do that, by making sure you review all the agreements. Plus, you've got to remember that more than likely, if the truck is not yours, the fuel certainly is, and the insurance and a lot of other things that allow them to do that. So you want to make sure that you're all on the same page. And I know this sounds crazy, but sometimes local fire departments do not get along with each other, and I've had situations where I represented a district and the contracting service provider would not enter into mutual aid agreements with anybody next to them. They went 2 or 3 fire departments over, sometimes even into another county for their mutual aid services, and that just makes no sense to have them traveling all that way. And so that's another way to make sure that you're getting the biggest bang for your buck and that your money's being spent efficiently. So if we go on down a little bit to Section 2, Section 2.1 on the contract, and you can see here that again we will allocate, or however you want to put it, because we're not really giving them money. You cannot give money away in the state of Texas. So the bottom line is that you have to have a contract with adequate controls to ensure the public good. There is no simple, as the Attorney General has said, there is no simple giving away or distribution of funds by a district to fire departments. Any distribution would have to be made pursuant to a contract, and such a contract must be in consideration for services furthering a legitimate purpose of the district, with adequate controls to ensure the benefits to the district residents are thereby realized. So that's why this contract is written the way it is. It's not because we don't trust anybody or we don't like anybody or anything like that. It's that we got to have a contract. We cannot, under the Constitution, give money away. And more to the point, you need to address how the proceeds of the money that you use, that you allow them to use from your money, your taxpayers' money, you need to make sure that if they're buying a truck with it, that truck belongs to you, because you're paying for it. And we'll get to it in a second here, but the law says that's yours, and that belongs to you until you decide how to sell it. If you use any district funds, whether through a contract for services or otherwise. So the bottom line is that that's what this contract helps do. And back when we contracted with Seabar Volunteer Fire Department, for example, to use my own area, we did not have a set number we gave them. We did have a set number. It was not in the contract. But what we would do is they would present us a budget. We would clean it up if we needed to, or ask why they wanted this or why they wanted that. And so the bottom line is that then we would come up with a number that's in our budget for the service provider. And it would be broken down into some into sub-items. Legal fees, if any, which you don't need to be paying for their legal fees. You need to be paying for only your own legal fees, for example, and we'll talk about that in a second. They can pay for their own legal fees. And then, have line items for personal protective equipment, fuel, whatever the issue is, and make sure that you've got a budget that everybody, including most importantly your taxpayers, can understand and follow. So, if you'll notice in here, in the section, if you go down about midway here with the sentence that begin, no funds provided by the district may be used by the service provider for legal representation, costs, or expenses of any kind or nature whatsoever of the service provider for legal representation. So the point is, unless we agree to it, the point is that they can pay their own way. They've probably got some of their own money. They may still do fundraisers. They may still be doing those kinds of things. But the bottom line is that you don't need to pay them to go fight you and pay your attorney too. So that's one of the things that are in there. In this particular contract, you don't necessarily have to do it this way. It depends on how much funding your department gets from other sources. But I usually have the service provider set up a separate account on which we are both signors and have the contract for, so we can pull money back if we need to, if there's an issue that requires that. But that way also we can tell exactly what does ESD money go for and what does volunteer fire department money for, so we don't cross those streams, and that's very important in this. Going on to section 2.2, the funds for the term of this contract shall be made available, not appropriated, not given to, made available with supporting justification complying with the district's budget process. Again, y'all will be adopting a budget. They will be adopting a budget. I think everybody wants to follow a budget. If you don't follow a budget, it's a spending plan, and that is not a good idea in anybody's world, generally speaking. So you will follow the budget, and it depends on how you do it. We used to make payments to our contractors on a quarterly basis. So it would be, October 15th and then quarterly thereafter. You don't want to give them a lump sum because it's harder to keep track of the money. Quarterly would be the most you would probably stretch it out to. Now there's always going to be things that need to be paid for that are there for 11 months and then gone in the 12th month. For example, insurance. It sits there and sits there and sits there and then it's gone. So you do need to make sure when you make draws or make quarterly payments to them that they understand that they need to have money there to make sure that those payments are made, like a big one, like an insurance payment or something like that. They have to, in my contracts and generally with my clients, they present to you, here's what we've done this month. Here's our P&L statement, our profit and loss statement, or some sort of accounting that shows. Am I going too fast?
No, you're great.
Okay. That shows that where they're spending the money and what they've spent it on that month. And also you need to know, call volumes and runs and times and all the things that you would like to know as to how your service provider is performing for your citizens. So they have to provide, in most of my deals, and the ESD sets these, you obviously want to work with the contractor to make sure that there is they have the ability technologically and otherwise to put together reports for you. We usually have, we did when we contracted with CBAR, for example, and the way it's contemplated to be set up under this contract is we would have the president of the volunteer fire department show up and tell us what's going on administratively and as far as the governing body of that fire department goes. Then we would have the fire chief show up to our meetings, and there we would go into the idea of what kind of runs did you make, that kind of stuff. So it's kind of like when you think about it, a city. You're the city council, which is absolutely true because you're a political subdivision of the state of Texas, and the 5 of you are city council members or county commissioners or members of the board of trustees, whatever it is. But in a city fire department, you would have a city manager who's handling the finances and the business and that kind of stuff. And then you'd have the fire chief who's handling the operational issues. This is how many fires we put out. By the way, the governor's mansion burned last night, that kind of thing. Now, and finally, if you look at 2.3 there, nothing in this agreement shall obligate the district to appropriate funds to the service, the full amount of funds. And that doesn't mean that we're going to hold it back necessarily, although we could. depending on the circumstances. We'll get into that later in the contract. And I've got to really rush because there's a lot here, and I apologize, I'm talking so fast, but we got to make sure we hit everything and still have time for questions. What this means is they can ask you for $1 million. My kids ask me for a lot of money, more than I have, all the time. And I'm not trying to equate them to my kids, but the point is they can ask you for $1 million. You either got it or you don't. And more to the point, if you have $1 million, you want to know how that $1 million is being spent. So they can ask you for whatever they want. That doesn't mean you have to give them that, which is another reason why I don't like to put numbers in there as far as how much we're going to pay them. It's all agreed for in the budget, but things change. Hurricane Harveys happen. Bad things happen, and you're going to have to revise your budget. It's not going to be the same thing that you started out with, and a budget, like a contract, is a dynamic document. You can change your budget, you can amend it, but you've got to go through the same process again of voting on it, adopting it again, making sure that it's tracked properly so your citizens can see it, so you all can see it, so the service provider can see it, and know how they're supposed to allocate these funds, and more importantly, so your auditor can see it at the end of the year and see that you've done everything that you need to do as far as a governing body of a political subdivision, and they know that the budget you set out with here got changed here, so you end up where you're supposed to be at the end of the year. All right, going into Section 3 here, if you could just scroll up just a tad there, right there. And 3.1, the funds appropriated to the service provider shall be transferred to the service provider, and this again goes into that account, a separate account, so you can easily audit it, easily grab back funds if you need to. We, in the legal business and discovery, we have what are called snatchback provisions. If you inadvertently give something to somebody that's attorney-client privileged or otherwise they're not entitled to, you can snatch it back, no harm, no foul. Well, it's sort of the same thing here. If they're misspending money, the last thing you want to do is have them sitting on a big old pot full of money that you can't control or can't get to or can't somehow make sure that it's not going the wrong direction. And occasionally people do steal money, they do misappropriate money, they do buy blinds and stuff for their house. So it just depends. So you need to be able to watch it. Now, I'm not saying you have to have a separate account, but I think that's really a better practice. So again, this also says that if you make less money in the year than you thought you were, the appraisals come back inaccurate, something happens with protests, etc., that y'all will automatically adjust the budget. You're not committed to a number that you now cannot fund or have to go into debt to do, which you really can't do, or have to go into your reserves that you have. All right. Again, 3.2 sort of says the same thing. The funding is contingent upon the availability of funds appropriated by the Board of Emergency Services Commissioners of the district. And it also says towards the end there that we don't make any representations that they're going to get any particular amount of money. That's up to the 5 commissioners to decide, even if it's an ongoing process through the year. And I know that's disturbing for some of you, and it's certainly disturbing for the service provider. But again, things change and budgets get amended. Funds do not come in. Harveys happen. And it says, in the event district funds for this agreement become unavailable due to non-appropriation, the district shall have the right to terminate this agreement without penalty. Again, you have the right of non-appropriation in Texas. In Texas, we have this concept called unconstitutional debt. And generally, and you'll see it actually in our statute in, let's see, I think it's 071, so bear with me. Yep. Except as provided by subsection B, a district may not contract for an amount of indebtedness in any one year that is in excess of the funds then on hand and anticipated revenues for the year. So generally you cannot, under the Constitution and under this law, enter into any long-term contracts. And some of you who've been around for a long time as commissioners remember that the way we got around this was through the use of lease purchases. We didn't really go out and get a car note like you're used to go getting for 5 years, or a mortgage for 7 years or 12 years or 20 years or whatever it was. We actually did lease purchases, and they were separate. If you had a 7-year lease purchase, they were separate 7 one-year contracts. And they could be terminated at any time due to non-appropriation. Well, this is put in here because this is something that the government has, and it's really hard to understand that if I'm leasing a building to a county government that they can just say, oh, by the way, we're done, and that's the end of it. They walk out. But that's basically what that says. Now, of course, there's a lot of exceptions under subsection B in that particular statute, which includes bonds and notes. It includes the ability to get 10-year notes for equipment if you're going to collateralize that equipment with your property tax revenue. It also provides for you can't have a mortgage and a note on a station, for example, an improvement that is in excess of 20 years if you're going to capitalize it with your property taxes. You can go longer if you don't capitalize with that, if you actually do a true mortgage where the station is what they come get if there's a problem with the payments. All right, so now to reporting requirements, and we don't want to make this onerous, especially for volunteer fire departments, but everybody in the district, including, most importantly, commissioners, has the right to see what is actually being done with the taxpayers' money. Most of my districts that I represent, and the way we did it in my ESD when we had CBAR Volunteer Fire Department, was we actually got reports on the number of runs we ran, the type of calls, an average response time, what kind of pre-plans we had done that month, because we asked them to do a certain number of pre-plans, and various things that keep us apprised of what's going on, and more to the point, keeps them focused on what they're supposed to be doing. So we had reports, and in my original contract starting back in '95, it actually had attachments, exhibits that went with this contract to ensure that we had the reports done the way we wanted them done. I've gotten away from that now. I really encourage us to, do we have any questions yet or anything?
Not yet.
I really encourage us as commissioners to work with the service provider. They may not have all the fanciest computer equipment or anything, and remember, a lot of them are volunteers, so again, we don't want to make it horrible on them, even though each of you is a volunteer. But work with them on the format to get what you need. And of course, a fire department and an EMS department, all those kinds of records, especially if they're a nonprofit corporation, are subject to the Public Information Act. So you can always get that information. I have had at times fire departments or EMS departments saying that's none of your business, when in reality it very much is your business. And under both the Texas Business Organizations Code, what used to be the Texas Nonprofit Corporation Act, and under the federal law where they've got their federal tax exemptions, it says everything. They've got to maintain books, they've got to maintain financial records, and anybody can walk in off the street and get those. That's setting aside the Texas Public Information Act. So with that said, what I do is encourage folks to, ESDs and their service providers, to work out what kind of reports they want, come up with an easy format that makes it easy for everybody to understand and to work with. In addition, what it says in section 4.1 is that in this case, those reports have to be delivered to the district by midnight of the 10th day of each month before the district's next regular meeting. And I'm assuming all of you out there have a regular monthly meeting that you've got a set time, day, and place for that to happen, even though you still have to notice it and everything so that everybody kind of knows when to expect it. But what this is, and it doesn't have to be 10 days, it doesn't have to be 7 days, it could be that night if you want. But what we're trying to do in this particular contract that this came from, this language, is we're trying to encourage the service provider to have those reports in well in advance of the meeting so our commissioners can read those, understand those, make sure they don't have any questions on those or need supplementation so that we can get that back from the service provider before the meeting. And more to the point, so the commissioners will show up knowledgeable and understanding so there can be a real true discussion between the commissioners and the volunteer fire department as to what's going on. All right, we go on to section 4.2. Well, going back to 4.1 for a second there, what I did is I changed it back. The format of these reports shall be deemed solely by the district. I want us to work together, but ultimately you have to set the parameters of what you want or not. And if the service provider does not comply with this provision or any other provision of this agreement, they would forfeit. In this case, this particular ESD pays their contractor on a monthly basis. And if they don't bring in all their reports, because they have 17 fire departments they contract with, if those fire departments do not bring in their reports, they lost that month's allocation. And it's forever forfeited. Now, that doesn't mean we won't work it out later. It's kind of like grounding. But the bottom line is that's what this provision says, is that if you don't get your reports in, then don't expect a check. So that's pretty straightforward, I think, and I think everybody understands why that's probably in there. It seems harsh, but again, this contract is a dynamic document, and I'm having to put all kinds of stuff in there that I never thought I would have to put in a contract because I just thought human beings would be able to figure it out. All right. The parties agree the service provider shall submit to the district an annual inventory and annual budget. You need to know what you have. You also need to know who owns it. You know, if you don't know how many trucks they have, you're at a disadvantage when they say they need another truck or something. And so you need to know what they have. Now, I'm not asking you to make them go tag and sort every box of Band-Aids or something, and I really literally get that complaint. You want us to go label every Band-Aid and tell you how many we have? No. And this actually says in here $100 or more, because there are many things that you need to know. But a case of Band-Aids, or more to the point, yeah, maybe a crate of Band-Aids. Number one, I don't know that anybody needs that many Band-Aids. In 25 years of providing fire services, I've actually used Band-Aids 3 times, I think. We have other issues going on and other things we use. But if you've got a crate of Band-Aids, you probably will not need to buy Band-Aids for the next 20 to 30 years. So that's the idea. So you need to know what's going on. And more to the point, it helps them know what's going on. It can be time-consuming, but every year you need to go over that. And more to the point, you need to make sure everybody understands who owns what. Which trucks are yours, which trucks are theirs, whatever it is, if that's the situation. You can agree on the value, the floor value. In this case, this contract's $100. But remember, if you go to something like $1,000, you could be missing really important equipment, because a lot of the pagers today are relatively inexpensive, but they're vital to the fire service, and they're vital to you to know. And they're also vital to know, why do you have 200 of them when you've only got 20 volunteers? Well, they keep losing them. That's the time, again, for a talking point and to find out what the issue is with that. Radios, you know, if you're on the 800 trunking system, they're enormously expensive and horribly difficult to deal with. But if you are still able to be on a VHF or a UHF radio system, then you get really good Motorola's or other providers that are $300 or $400 or $500. And radios are vitally important. And if you have a big threshold up there of $1,000, you're never going to get that. Now, you can do it separately, but that's the idea. You can put a number in there. It's really hard to sit there and say, I want everything that you've got. But that's the idea, is just making sure that you have a good, solid knowledge of your service provider and their capabilities. And remember, those of us who've been around for many years, we've paid for everything. There's probably not a lot of fundraising going on by the volunteer fire department anymore, or the volunteer EMS squad. There may be, and they're certainly free to spend that money the way they want. And I'll go off on a tangent now, sorry. They're free to spend that, but if they want to buy a hot tub with that money, maybe you need to rethink what your tax rate is and what you're paying them for. If they've got enough money that a hot tub or something like that is on their wish list, then you need to reevaluate what you're paying them for, and if it's really a spending plan or a real budget. Okay, but going back to the inventories, and well, I lost my train of thought there because I always do, but you don't consider any appropriations until the inventory is in and the annual budget and appropriation requests are in, because you need to know those things, because that's really the main thing that you do. So that's in this contract too. Now we go on to the next one. You want them, of course, in 4.3. You want them, of course, to comply with and maintain compliance with all licensing, training, fiscal or other requirements, and that includes you. Because it says in here, state, local, and federal law or administrative regulations. Well, you are a political subdivision of the state of Texas. Basically, when you vote on something, it is essentially equal to, you can call it an order, but it's equal to an ordinance, it's equal to a statute. So the bottom line is that local includes you. And so you want them to comply. But more importantly, there's really not someone who licenses volunteer fire departments out there. There is the State Firemen's and Fire Marshals Association, who certifies training and meeting certain requirements, and that's always something that you want to encourage your fire departments to do. On the other side, with EMS, or if you're doing fire first responder, you've got to know that the guys going out to go help somebody with a broken arm or something actually have some training to do that, and the state of Texas requires that they have at least an emergency care attendant. They've changed the way they do it now, but an EMT. So they need to have everything they need to have, the FRO agreement, first responder organization, whatever they need to have, it's on them to do. We also require that they comply with the National Incident Management System, which is really required by federal law. but it's also good practice. And also, we in this case also have them do the text fire and infer reporting systems and work with the Forest Service. And that helps us when we want to go get grants and stuff too. In 4.4, you can see that we require them to do an annual audit, and we audit them. Some of my districts that have more than one service provider, they may not do every one every year. When you have 17 service providers, that gets to be very expensive at $4,000 or $5,000 a pop. So what they do is a rolling audit every other year or every 3 years. You might be getting audited just to make sure that everything's where it's supposed to be and the money's being spent like it's supposed to be spent. Yes.
So the audit is paid for by the district?
Yes.
Okay.
And I'm glad you noticed that, because that was the next place where I was going, is that the district pays for it. I mean, I really don't believe in unfunded mandates. The federal government gives enough to the state gives it enough to the locals. So if you're going to ask them to do something, training, an audit, you should pay for it. And more to the point, this isn't your audit of them, not their audit that they're getting and providing to you. Now, they got to provide all the books, and again, those books are available under the Texas Public Information Act, under the Texas Business Organizations Code, and under the Internal Revenue Code. So you can get all those documents, and you got to be wary of somebody who doesn't want to share that information with you. There's a reason they don't want to share that with you that I found in my practice. But you pay for it because really you want your auditor looking at it for your purposes, not necessarily whatever they decide they do. And you can even do an audit on agreed principles, but of course you have to, as an ESD, we have to every year do an annual audit with some exceptions that we have to provide to our counties and that the public is entitled to get. And if you think about it, 70 to 85% or more of your budget is the volunteer fire department, and it's really not much of an audit if when they do your audit and they see that you spent so much on computers or whatever, or this safety webcast or training, and then there's a big number there of $500,000 that just went to the volunteer fire department. That's really not telling anybody anything about how your money is actually spent. So I always require that they have to submit to an annual audit. And then 4.5 is this is people behaving badly. Any report filed with or presented to the district by the service provider that is false or misleading in any way will result in addition to any other remedy the district may have hereunder otherwise, the loss of funds for any periodic payment to be made by the district to the service provider and subject to the service provider, and subject the service provider and any individual who presents or files same to further appropriate legal action. You are a political subdivision. When they're filing these reports with you, they are filing official reports with a governmental entity. There are crimes that are involved with that. So, and this, this is one of those things that I wish didn't have to be in a contract, but you would be amazed what people do and what they file. And if they're lying about it, I now want them to understand that there could be civil and criminal problems with that. All right. And financial, because again, if your kids lie to you about something or misrepresent something to you, you're probably not happy about spending your money on that. All right, the district may suspend payments hereunder or withhold payments as appropriate for any violation of the provision of this agreement. That usually gets people's attention, and again, I hate to equate them with my children, but when I cut off the money for my children or they haven't mowed the lawn and they're not getting any money, that tends to get their attention and the lawn tends to get mowed. So that's why that's in there. All right, 5.1 addresses mutual aid agreements. We used to have a standard mutual aid agreement that we put in there. Nowadays, it's getting very complicated. You want to be careful about how you do that. Most of us have gone away from having written mutual aid agreements and do it under the statewide system, under the statute. But if you have a mutual aid agreement, and again, this section more is, the 5.1 section is more for an ESD that has more than one service provider. Because stunningly, sometimes those guys don't get along. And so you have to put an agreement in there to make sure that they actually play well with others and that they actually send a truck over to us when we have a house on fire. And conversely, we send a truck over to them. And that's more internal within the ESD with more than one service provider. But again, you want to make sure, and again, this is why I want you to review those documents and make sure that you have those mutual aid agreements. We learned a very hard lesson, and this is not exactly the correct story, but this is the way I remember it right now. But here in Travis County, we had all the fires on September 11th many years ago in 2011, the September Labor Day fires. And we all had a written mutual aid agreement between all of us, the city of Austin and everybody else. And that was swell that we had that. And we went to the Texas Forest Service and the United States Forest Service to get our reimbursements because we literally spent months on these fires working each other's fires. And on one day we had the fires going on in Bastrop County where we all kind of looped over there and then realized, oh my God, Travis County's on fire. And it started with Pflugerville, then it went to Pedernales, then we had one in Steiner Ranch, and then Leander and Williamson County was on fire. And it was a very ugly situation. So when we went to get our federal and state reimbursements, they said, oh wait, we see that you have this mutual aid agreement. And this mutual aid agreement said you're going to be there and it doesn't limit the time you're going to be there. So we don't have to refund you. We don't have to reimburse you. Thank God we looked at the contract a little closer and realized it had expired on September 10th, 2011. So we didn't have that thing to have to work through. But that's why you need to see what agreements they have to make sure they're right and run them by your legal counsel, because you don't know what could be out there that has changed because somebody pulled out a mutual aid agreement they found in the cabinet and dusted it off from 1947 and said, well, this will probably work. And it's citing Texas Revised Civil Statutes or maybe even Georgia law for all you know. And so you want to make sure that they're right. And 5.2 talks about first responder. Again, if your folks don't provide first responder, that is what it is. I think first responder is very important, especially in rural Texas, because there are only so many ambulances out there, and being able to assist folks is a great, great, great benefit to your taxpayers. All right, so it is about 7:10. I got to really start looping this up. All right, so the service provider in 6.1 agrees to use the funds appropriated to maintain its physical facilities, educate its members, purchase equipment, repair and maintain equipment, pay operating expenses, et cetera, et cetera. You really should, if they need a new fire truck, you should buy the fire truck. It may be less money in their budget, but it's all going to the same purpose. You should really only be paying M&O. Anything that's a big capital expenditure, and you can talk to your auditor, it may be over $5,000, but you buy a bunch of SCBAs, or you buy a brush truck, or you get a skid unit, you need to own that. There's no reason for you not. And who's paid for it? You have. And there's plenty of case law out there, including in the Blue Book, that talks about, in Texas, if I pay for something, if I'm paying for your house, the deed may be in your name, I own that house. Yeah, you have the deed, you have the legal title, but I have the equitable or beneficial title. And all I got to do is go to court, show the court, I paid for it. And I own it. Absent it being your child, but then it's presumed to be a gift. And there's cases on that involving volunteer fire departments, but that gets us into section 6.2. The law itself says in 775.073, and setting aside the Constitution, any property, including an interest in real property, purchased or leased using district funds, wholly or partly, must remain the property of the district, regardless of whether the property is used by a third party under a contract for services or otherwise, until the property is disposed of in accordance with applicable law. All right, that's really fast and really hard, but what that means is you own it. And you do not need to be paying for a truck that's titled in Ken Campbell Volunteer Fire Department, to where if Ken Campbell Volunteer Fire Department and Chief Ken Campbell, who's always hard to get along with, decides he wants to walk off and take his ball and go home, you paid for that ball. And if y'all have been around for a while, you've paid for that ball completely. And you've paid for 2 or 3 of those balls over the years. So the point is that you need to know what you own, and if you're paying for it, you might as well own it. You can probably get a better interest rate too. Yes, sir?
And important on when you say you, it's important for y'all out there to remember you is you, the district, on behalf of the taxpayer. So that's the important distinction there, is you're owning it on behalf. It's not the district. You're not greedy. You're not asking for anything. You don't. It's not your private anything. It's your job as the ESD commissioner to be the stewards of the taxpayer money, and the tax dollars that are going to this property, you, on behalf of the taxpayers, own it, essentially.
You're exactly right. And if you think about it, and truly this is the case, I know some people may not like this philosophically, the volunteer fire department has never paid a dime for anything ever. Ever.
It's a nonprofit.
All of their money has come from state grants, federal grants, state money, the county, an ESD, a city. It's just run through their accounts. Who owns that stuff? Even if the station is titled in Ken Campbell VFD Inc., who owns that station? Well, the people there who paid to build it, who went to the bake sales, who went to the spaghetti suppers, who did all those kinds of things, they're the ones who paid for it. It may have run through the VFD's account, but what you really don't want to have happen is that you get in there, you're an ESD, they decide to go home, and now you don't have any fire stations or fire trucks. Yet you still got to provide a service. But you've paid for all that stuff. So what you really want to do is make sure that you know what's going on, and you, of course, talk to your legal counsel. But the bottom line is that y'all work it out. If you're not going to have it titled in your name, there needs to be a very good reason. And what's funny about that is, too, is I even had an ESD one time where the volunteer said, well, we're going to use some money from a bike race thing that happens every year that's annually raises money for our services. And because they asked us for a brush truck, we said, we just bought a new one. We don't need another one. And they didn't agree with that, so they said, well, we're going to use our money from this fundraiser. And that was all well and good. We told them that's fine, but you're also going to have to insure it. You're also going to have to put fuel in it. You're also going to have to put water in it at your own expense, because that's what you want. Now, because we don't believe you need it. And the funny thing about that is 3 years later, that fundraiser thing went away. Now they can't make their payments, and they came back to us and said, oh, would you help us with this? And we said, sure, as soon as you title it over to us, we'll be glad to do that. And that's what we did, and then we sold the thing because we really, really meant it when we said we didn't need it. But that's another point. You own it, you're paying for it, you own it, and I'm really going to have to start moving here now. Also, this section gives them the ability, if you own the fire station or the fire truck, this section gives what's called a license, which is personal to the person. It's not part of real estate or anything like that. You really don't want to lease them anything, especially if it's real property, because then even if the lease is over, you may have to go evict them and go to court to do it. And it's really weird. This happens a lot. I have to deal with this a lot where we have the volunteers living in the station. And that's all well and good until you fire them, but they don't want to move out, and then you have to go evict them because you can't move them out under a lease. So I give them what's called a license, like a hunting license or a grazing license. I can terminate it anytime I want, and it's only good for so long as we do the contract for you to use, you the VFD to use, us the ESD stuff. 6.3 again talks about sort of the snatchback provisions, that if they misuse money or violate the law, then we can suspend payments, we can not send more payments over. We can make them pay back that money that they've misused. It does happen. Mutual aid is also important. Again, you want to do mutual aid. You want to encourage them to do mutual aid, even if it's a little lopsided, because when you need them, the other people coming to help you with mutual aid and you've been giving it out a lot, you may really need it. So, but again, you want to see if you're running out to somebody else's fire department 6 times a month because they can't get enough volunteers going there. So you're into that situation where you are now subsidizing somebody else with your taxpayers' money, which creates a constitutional problem and a fiduciary problem and a financial problem. 6.4 talks about they must provide us all the stuff for the audit within 60 days of the end of their fiscal year. We, of course, have to have our audits in on June 1st. Can get an extension till July 1st, and then there's bad things that happen after August 31st. But you want to go ahead and get started on that. If you're not on a calendar year, this means that when your fiscal year ends in September 30th, you should be looking at getting that audit in to your auditor at worst case by January 1st, and that'll still give you 6 months to get it right and get it to the county. All right. I asked them to put in, have policies and procedures on how to handle things. I asked them to be nice to everybody, which I know sounds crazy that you would have to ask somebody that or put it in a contract, but you'd be amazed. Some people think that because they're a volunteer firefighter, they're also a cop, and they're also the FBI, and they're also the President of the United States. So we need to, just have that in there. We want them to do criminal background checks. The days of we'll take anybody as long as it's a warm body are gone. We're going into the middle of grandma's house in the middle of the night with volunteers, and we do not need registered sex offenders or people with criminal records, especially of theft, going in there when they're most vulnerable, when they're sick, when they're asking for help, when their house is on fire. Because if nothing else, and I've had this happen, we had on one of the departments where one of my ESDs was contracting with him, he was a good guy, and I believe in rehabilitation, but he had a criminal conviction from 5 years ago for theft. Well, he went into a house where both the residents of that house had dementia. Daughter knew of his history because they all live around each other, knew of his history, and immediately accused him of stealing all the jewelry. Well, we would not have, we may still have that issue, but we would not have an issue where we've got a convicted thief going into the mom and dad's house when they're disoriented at the middle of the night. It turns out the daughter actually stole the stuff and was trying to make an insurance claim, and she could also goad somebody that she's hated since high school. Okay, but the point is that those days of taking anybody just because they're there is gone. You need somebody with a good driving record, with a clean criminal history. Doesn't have to be perfect. You can have a DWI maybe 10, 15 years ago, but you still need to know that so you make sure they're not ever driving the truck. Because even if it happened 10 or 15 years ago, if the plaintiff's attorney can get it in that you let a guy who had a DWI from 15 years ago drive a fire truck, even if he wasn't drunk, even if he wasn't at fault, that's still an issue that you have to deal with. So we make them do that. Again, no unfunded mandates. We pay for that. There's many ways to do it. You can do it through DPS. You can do it through your fire marshal. There's a lot of ways to do that. 6.7 requires that they have their bylaws and their organizational documents set up so they remain a first responder or, an emergency services organization under the Texas Civil Practice and Remedies Code. That's very important because they could lose their immunity and you could lose your immunity. And I won't go into that because that's a whole other class, but you need to have that done. Again, you have standard operating guidelines. We're getting down into 6.9. This is just to play well with others. I've had this happen before, especially when a volunteer fire department is upset with some of their commissioners. They actually started wearing, they were against the current county commissioner who had appointed their commissioners. And so they went with the other county commissioner and said, we'll support you if you make sure all these guys are no longer commissioners. And they started wearing their buttons into EMS calls and fire calls and wearing them around the firehouse and in the ESD meetings. That's all well and good, and there is a free speech issue. We're just asking them not to do that. Plus the fact I'm from Austin, Texas, and I can get behind somebody and they've got 97 bumper stickers on there and I know everything I ever needed to know about them and I really didn't want to know it. So we don't need people with that on, all over themselves going in to help somebody in the middle of the night. The service provider, 6.10, service provider has other sources of income and they can spend it how they want, but if they spend it wantonly, you need to rethink your spending on them. And more to the point, they still have to account for it because if they're making $1 million and you're only providing $300,000, yeah, you can say that you're just the tail, but at the same time, if they're making $1 million, maybe your tax rate doesn't need to be 10 cents per $100 valuation. It might need to be less if they're doing that well financially. But again, that's all part of just knowing who your service provider is, and it's not because we're nosy, it's not because we're jerks, it's because we have a right to know. And the law says we have a right to know, and we're paying for it, so we have a right to know. The first responder, that goes into first responder. We have the treasurer be at least insured, if not bonded, like your treasurer has to be. Bonding's a little complicated of an issue. I won't go into it too much, but you need to at least have $300,000 in theft or dishonesty insurance, if not a bond, actually. 6.13 talks about how they are an independent contractor. I know it seems we're getting into their business a lot, but I can still tell my independent contractor plumber who's putting in my hot water heater, replacing it or something, don't drop it down or don't ruin the carpet, that kind of stuff, So that's the same thing. They've got to maintain all insurance. We require that. 6.14 and 6.15 go into that. 6.15 has a whole bunch of different requirements on how much coverage you have. Everybody who has VFIS or TML should be able to hit this no problem. All right, performance statement. This is kind of important. This is in this particular contract. This is an issue we're really running out of time. Do we have any questions?
No, we're just, let's go all the way through.
The service provider shall, participate in SFFMA. They are the ones out there. You'd like them to be getting training and paying attention to what they're doing and actually doing something and know how to put out a fire, or continuing training with EMS. That everybody's properly trained or certified for the level they want. 7.3 assure that they respond to calls. And you'd really like them to respond to all calls, although sometimes the volunteer fire departments, especially on holidays and stuff, they get missed. But more to the point, I'd rather they not miss it. I'd rather they make arrangements with their neighboring fire department to tell them. And we used to do this with Westlake a lot when we were at Seabar, even though we're all in the same school district, because they were all going off to watch our football team play in the state championship or the playoffs, and they would have no firefighters. So they would let us know, and they would sometimes even give us the key, and we'd go over there and sit in their station. So that's really just to make sure that there's some coverage there. You want to send them to an approved schools. We require in this contract one FEMA or Fire Act or other kind of grant be applied for every year. If you have a volunteer fire department, they can meet this requirement just by doing the workers' compensation reimbursement from the Texas Forest Service. And you need to have your volunteers have workers' compensation. They deserve that. Prepare and submit financial documents and other reports. You have a question?
I just wanted to know, you put in a service provider response time. You actually
Right.
named it 15 minutes.
Right.
Is that pretty standard?
It's an average response time. It depends on your district a lot, too. I mean, in our district, you could probably make that easily. You've got other districts that are huge,
Right.
and that's hard to do. But an average, that's why it's an average. An average of 15 minutes could be should be reasonable, because there are times when you have 0 seconds going to call because you happen to be there before it actually gets toned out. You actually tone it out or whatever. 15 minutes, and really it's just some sort of measurement that you have out there just to see where you're at. I mean, they may not be able to make it, but when you start having response time requirements of 20 minutes or 30 minutes, I mean, what's the point? I mean, at some point it doesn't matter. Yeah, we've never lost a slab, you know. So, you know, at some point it just becomes ridiculous. And mom's dead by then in a heart attack 20 minutes into it.
Yeah.
But this is just to put some sort of standard
Right.
in here. And 15
Gotcha.
minutes has historically been a pretty good
Okay.
parameter, even for the larger departments. This one requires that they have so many members, 8 members, and this one is one that has multiple contractors, and this is in 17 excuse me, should be 7.9.
I got 7.9.
Yeah, I know, but then it goes to
17.
I'm seeing 17 here. I got a typo in here. We require them to conduct at least one training drill, at least 2 hours in duration. And that's required under state law to be a volunteer fire department, which nobody pays attention to. I'm not going to go through the rest of these, although we do require their fire chief and their president to be at our meetings. And we ask them to follow NFPA standards. We ask them for yearly pump tests. We make sure that they do training and drills and they operate under the NIMS. Number 8 is a big important one. All equipment purchased with funds from the district may be used by the service provider and or titled in their name, but basically we own it if the district pays for it. And that's what this is saying, and we get it. And if we have to go to court to get it, then they get to pay our attorney's fees too. And it also says, title to all funds dispersed to the service provider by the district shall remain in the district, as well as any title to any real or personal property purchased therewith, which is just repeating what the law said earlier in that 6 point whatever. And in that 6 point whatever section that we also talked about, 775.073, that's also saying that if we paid for it, we get it back at the end of the contract. Now, you can vary this how you want, but again, your volunteer fire department has never paid for anything, so you really want to try and keep it there so you don't have to rebuy a new fire station and they turn theirs into a Jiffy Lube, or rebuy a fire truck that you just bought a brand new one and they've walked off and sold it to somebody else and you don't know where the money is now. Indemnification, they should indemnify you. The law says that. We go to Section 10. I'm sorry, I'm getting ahead of you there, Clay. At 10.1, and 10.1 basically says that we have a work it out, a cure period, where we tell them, we've got a problem with you, here's what you violated in the contract, you have 30 days to fix it, and they tell us it didn't happen, or they fixed it. And then, of course, if we can't agree on all that and we go to mediation, then, which you don't have to go to mediation, then the county judge there will select the mediator. And then 10.2 says we can terminate this thing at 90 days' notice. They don't get a termination provision. They only exist because you say they exist. And because without you, they would not exist. They created an ESD for a reason, but you get to pick who the service provider is. And if you pick somebody else, they don't exist anymore. And that's, I mean, they may call themselves Ken Campbell's Volunteer Fire Department, but 911 is not calling them. They're not going anywhere. So we can terminate that, and that's just because you might have to do that at some point. You get into some of the boilerplate stuff here, and we're almost about 2 minutes away, but you know, when it's executed in your county, the venue statutes say the suit has to be in your county, and we're doing that. They also have to pay us our attorney's fees. We're not paying their attorney's fees if they sue us and they win, because more than likely they're not going to win, number one. Number two, unless you've done something really stupid, which I'm hoping your lawyer will stop you before you do. And number two, if they're making us go to court and spending our taxpayers' money on something other than boots and water and hoses, they get to pay us back for that. And by the way, as a political subdivision, you generally don't pay attorney's fees, so I would not agree to pay attorney's fees in something, generally speaking. In 11.4, you see that it goes from October 1st, 2017 to September 30th, 2018. You need to have an annual contract. Every contract you can do, you can say it's a 100-year contract, is based on annual appropriation, and you cannot bind future councils. So you can always get out of contracts. It's a thing called sovereign immunity. There are exceptions to that rule. This is not necessarily one of them. But you do also have an evergreen provision that says if we forget for whatever reason to renew this, that it goes on a month-to-month basis, and then you can terminate on month-to-month until a new contract is entered into. And then we finally get down to, we're almost out of time, like in 11.9 on page 13. Sorry, I'm really skipping on you now. For example, they are authorized to bill. Remember, they're not authorized to bill, and basically nobody pays volunteer fire departments because they don't have to. But our law says that if we spend our money on it and we send you a bill, you get to pay it. It doesn't matter whose fault it is. And one of the unfortunate aspects of EMS law is the EMS company does not bill the shooter, he bills the shootee. And the shootee generally didn't have anything to do with it, but he gets to pay for the ambulance ride too after getting shot. But my point is that we don't have to worry about fault, who shot whom or anything like that. But they don't have the legal power to do that. You do, and you have to pay attention to that. If they're doing a billing program or a billing system and they're not collecting, then they have to come back to you because they're using your money, and then you can use your lawyer to go sue whomever you need to sue to get that money back. And I'm not talking about structure fires. You can bill for structure fires, but to me that sounds wildly inequitable because they're already paying taxes. But certainly on EMS or controlled burns or other legal violations, we have a policy. The only thing we bill for is controlled burns where you didn't call us. We call it our stupid tax. And then you get billed for that. And we have a billing sheet from the Forest Service, so it's all reasonable. And then we allow them to keep ranks and titles, but we can change it. We can decide to get our own fire department. We can decide to appoint an administrator to tell them what to do. So that's all in the contract here, and that's pretty much all of it. And we are a little over time, I think. But that's the contract, and I encourage you to talk with your attorneys. I know that the other attorneys that I work with in Travis County, well, not in Travis County, in Texas, John and our great emeritus attorney, Howard Katz, we all have a different approach to this, and we word it a little bit different, but we all have basically the same parameters in our contracts because we all understand that we work for an ESD and contract with a VFD. And so we have to have certain things in there to ensure the public good. And that's about all I got.
Excellent.
And I actually fit it into an hour. I can't believe it.
Okay, you did. And there's a lot of information in here. I'm going to ask this one question because I want to know. We don't have a time for any more. But Ken's a pretty easy guy to get a hold of. So if you do have any other questions, send them to us and we can filter them through. The one question that I want to get to, if a VFD gets the grant, but the ESD pays for the skid, whose name will be on the title of the vehicle?
Well, the skid is not a titled product, but you will own the skid unit. Now, you need to talk about the truck, and I have this happen all the time, and I'm glad you brought this up. We get a lot of grants. My clients, the VFDs, get a lot of grants, and they usually come to us, the ESD, and ask for the matching funds, 10%, 20%, whatever it is. As far as I'm concerned, the federal government or whoever gave that grant, owns that part of the truck, and they can't give things away either, but it's a grant, so that is exactly what they're doing. But my point is you own 25%, 20%, whatever the matching is on that truck, and your name needs to be on the title too if you paid any money for it. Now, skid unit's separate. You can pull it off and put it on another chassis, and that's something that's not titled. But if you pay any money into something, I think the best way to do it is just tell them, we own it. Sometimes when I have where they've gotten a Forest Service truck and they can't title it in our name because it has to remain in the Texas Forest Service a certain amount of time, we do a side contract that says, here's how much money it costs, here's how much money you got from the ESD, here's how much money you got from the federal government, and we own that percentage. So if they ever go to sell that truck and they bought it for $100,000 and we paid $20,000 and they sell it for $10,000, we get $2,000 off the top. They can have the other $8,000. But that's how it works. So you need to make sure that kind of stuff, because you're getting an ownership interest, not necessarily the whole thing, but, and this happens a lot too, and I'm sorry I'm going off on another tangent, but when they want you to repair the roof on the fire station, that's a capital item. And you can't take that roof home with you if y'all ever go separate ways. But the taxpayers own that roof, period, end of story, no further explanation needed. So you need to work it out. Usually the easiest way, and it's sometimes painful, but it works most of the time because everybody understands the issues, is when they go to that kind of big capital expense, we say, as soon as you title it to us, we're more than happy to put the new roof on it. As soon as you title it to us, we're more than happy to put that skid unit on it. So you just need to work through that. And again, we're all in this together. We're married. We're not doing this to create fights. We're doing this to make sure there are no fights in the future. Okay?
Excellent. And with that, I know we're running over. I'm going to do my little soapbox. Please, if you contract with a service provider, please make sure your agreement is up to date. Some people are working on agreements that are years old, years plural, maybe decades plural old. There's a lot of issues that Ken covered tonight. We only had time to get into a few of them in depth. Please, this solves a lot of problems if you have everything contracted or at least tried to agree to things ahead of time. So that's my little soapbox. Well, a lot of the calls we get at SafeD are usually when things are going wrong and I say, what does your contract say? And I get silence on the other end of the phone because they either don't know or there is no contract. So know what you have, know what you've agreed to, and redo it if you need to. Do it yearly, like Ken says in this agreement. So thank you, Ken, for being here tonight. It's always great. A lot of information, and I know we're running over. I want to get really quickly. Thank you all for joining us tonight. We have several training opportunities coming up. Check out our website, safe-d.org. This Saturday, we're going to Ellis County, North Texas. We're going to do 3 hours of commissioner training in Waxahachie. Big thanks to the Ellis County folks for letting us use their building, allow us to keep costs down. The following weekend, we'll be in Harris County at Ponderosa Fire Department. Big thanks to Chief Windish and his folks out there for letting us keep costs down and allowing use of their building. That's going to be another, both of those are 3 hours. So you can basically get all your training for a year at those workshops. And again, we're trying to hit North Texas and then the Houston area. And we've also, I was just speaking with Ken, we may be able to do a local Central Texas workshop. He may be willing to do one after the first of the year. So keep in mind, watch our website for that. We're also doing another. We'll be right back here last Monday this time, a real last Monday after Thanksgiving. We'll be talking about the new annexation law. So a lot of training opportunities coming up. Go to safe-d.org to register. Of course, the big one is in February 22nd through the 24th. That's the annual conference in Galveston. Had a lot of people sign up already. Hope to see you there. I'm hoping Ken will be there. We haven't talked much about it yet, but we will be talking in the near future about Ken being able to present some of his great information at the annual conference. So
got to get my CEs too.
Yeah, and he's a commissioner too, so he's got to get those done at the same time. Okay, so with all that out of the way, let's get to your hour of credit. Sorry we ran over a little bit, but it was a lot of great information, so we needed to get through it. For tonight's webcast, you're going to go to the following link. It's www.safe-d.org/webcast17116. And that's it. Should be, is it below my face, yes. Producer? Yes. And your keyword, you're going to have to enter that keyword or we won't process your credit hour. The keyword is Tango, T-A-N-G-O, one word, all lowercase. Once again, that's safe-d.org/webcast17116. And the key password is Tango, T-A-N-G-O. It takes two to tango. We're all trying to get along. Tango, one word, all lowercase. That information should be below my face. So without any further ado, thank you so much for joining us. Keep checking the SafeD newsletters, both print and electronic, and our website, safe-d.org, for all the information about future trainings and all the things going on at SafeD. Hope to see you again in the future. That's our webcast for tonight. Thanks again to Ken Campbell. I'm Clay Avery. Good night from here in our new studio in Austin.